Good afternoon or good morning if you are joining us from BC or Alberta. This is once again our regular Q&A installments of the employment Q&A sessions. So I'm Sephton Leibbrandt. I'm an employment lawyer associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you everybody for joining us this afternoon. We'll be answering all of your questions on employment law during the next 30 minutes. And in case perhaps you cannot entirely tell, I'm a little bit under the weather today, so please forgive me if everything is not entirely clear. I sound a little bit nasally. It's that time of year again, unfortunately, so bear with me in that respect. So thanks to everybody for tuning in again. I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So while we wait for some questions to start kind of populating in the chat here, probably top of mind again as everybody's thinking about these days is the ongoing trade war, unfortunately, with the United States and how that's affecting very significantly our economy here in Canada and our labor market especially, which is extremely weak right now as a product, unfortunately, of that ongoing trade war. So one of the news stories that I've kind of seen of late, in addition to many companies unfortunately doing the same thing, but appears that Puma is intending to terminate or to remove about 1,300 corporate positions, in their corporate offices here as a restructuring, a very significant amount of jobs. And that's of course just for those folks. Generally speaking, obviously we know that employment opportunities in Ontario are at an all-time low, effectively since the pandemic. The economy has lost a very significant number of jobs and is not adding jobs nearly as sufficiently or as significantly as it should typically be doing in the circumstances. For instance, I had read the other day that approximately we were adding around 8,000 jobs or 10, 15,000 jobs to be along those lines, when we typically add approximately 60,000 jobs every month to the labor market, previous to this kind of time period, and post-pandemic as well. So it's clearly a very weak job market out there, unfortunately. And so a lot of people ask me, because my employer may not be doing very well, financially, economically, and I've been terminated, does this mean that they get to pay me less money in my severance package? And the answer to that question is absolutely not. Your legal entitlements, at law remain the same, regardless effectively of the employer's financial circumstances. Just because the employer may not be doing well financially, does not mean to any extent whatsoever that they get to pay you less money in your severance package. Your severance package is determined primarily by your years of service, your age, and your position, and some other factors, including your rate of pay and availability of employment. Those are the determining factors for how much money you're owed, at common law in a severance package. And so that amount is not affected by the particular employer's financial circumstances. In fact, the courts have actually said almost exactly the opposite, that in times of economic hardship, as we are currently going through, that can actually lead to a greater severance package having to be paid by an employer, rather than a lesser severance package in the circumstances. And the courts have taken judicial notice of the fact that the economy and the status of the economy very significantly affects an employee's abilities to attain alternate comparable employment, which is the whole purpose of a severance package. A severance package is simply to tie one over from one job to another comparable job, and that is exactly it. So if it's going to be the case that the economy is quite poor and jobs in your field are obviously going to be significantly less as a result of that, naturally and necessarily the employer is going to have to pay you more money, because it's going to take you longer to find that alternate comparable job, which is the purpose of your severance package to begin with. So that's a question I get very, very often. And further to the general common law obligation, if it's the case, for instance, if you're similar to Puma employee who's been terminated, along with potentially a lot of other employees, in a mass termination set of circumstances, then and you're a provincially regulated employee, of course, as well, then you are actually potentially entitled to more minimum notice under the Ontario Employment Standards Act than you would be if you'd been terminated individually or with a fewer number of employees. If it's a mass termination situation, so typically 50 or more employees, then the Employment Standards Act provides for a greater notice period to the employees who are affected than would otherwise be the case. And again, that's just for one's minimum, entitlements under the ESA. If it's, again, ultimately, what you're looking for is a severance package, a common law, because a common law severance package can be up to 2 years of compensation. That kind of severance package, again, can be, affected in a sense of, improved and enhanced by the simple fact that the economy is very poor and that a particular person's position is very difficult to find or locate in the current job market. So again, the long and the short of it is that the bad economy does not mean that employers get to pay any, even a cent less than what they're legally obligated to pay to you. In fact, it may result in the fact that the employer may need to pay you more money than would otherwise typically be the case. So it looks like a bunch of questions are populating now, which is fantastic. So I'm going to get right to those right now. And if you're just joining us, again, I'm Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you again, everybody, for tuning in this afternoon. So it looks like a number of questions from YouTube. Looks like JK Nets from YouTube has asked, cleaning staff employed by the Hospital of Toronto placed a video recording device in staff washroom. It's currently under investigation with TPS. Staff members spoke to union and TPS. All they get is still under investigation. What other legal options? So if they're unionized, employees, then that would be, governed by what the collective agreement provides. So we deal with, only really non-unionized employees because when you're a unionized employee, you have to go through your union representatives, and the union, of course, will have lawyers that represent them. And so, unfortunately, any circumstance where it's a unionized person being affected and anything to respect to their employment, we unfortunately cannot assist with those kinds of situations. We only deal with non-unionized employees and their legal entitlements, which are determined by the courts and the case law, basically, that looks at what employees obtain in severance packages and things like that, or the laws generally. Everything in this circumstance, if this is a unionized situation, which it sounds like it is, number one, they have to look at the collective agreement to determine what they do, but probably the case is they'll have to reach out, to their union representative. If they need to file a grievance, then their union rep will assist them with doing so, and then it'll be, again, the union's option in terms of what they wish to do in this particular circumstance. Sounds like a very serious and concerning allegation, and I'm sure the union's legal counsel will have the right advice to provide in that respect. But unfortunately, in terms of other things to do with respect to employment law generally, again, nothing that unfortunately lawyers like ourselves can do to assist, because in a unionized workplace, it's the collective agreement that governs the employee's entitlements, and against unions, legal counsel, that is the only authorized person to represent that individual, nobody else other than the authorized person. So hopefully that answers your question, JK. So I appreciate the question, because it's a question I get occasionally here and there. Folks who are unionized and want to hire a private employment lawyer, and whether or not they can do so. And unfortunately, it's the case that typically one, in almost all circumstances, cannot hire a lawyer like ourselves at Samfiru Tumarkin, simply because, again, the union has their own lawyers, and they are the only ones who are authorized to represent you in the circumstances. So I appreciate that the question. Moving on to, looks like Jessica from YouTube has asked, I work for a Canadian branch of a Chinese tech company that has been affected by recent U.S. trade restrictions. Management announced that operations will transition to a new company abroad and is asking employees to resign and join this new entity. Okay. Oh, it's more further questions here. We haven't yet received any official documents, only verbal and email updates. I'd like to understand what my rights are under Ontario labor law and what I should do before making a decision. So Jessica, absolutely you wouldn't want to resign, ever from your employment. I don't know how long you've been employed with this particular company for, but certainly, you would not ever want to resign in terms of, that would obviously somebody who resigns is not entitled to, a severance package, number one. So, if it's the case, the company wishes to terminate your employment, which it sounds like what they wish to do, then that is, something for you to look at and see what they'll provide you in terms of a severance package. And it sounds like that documentation hasn't come forward yet. But, in terms of, resigning again, this employment, it depends again how long you've been there to some degree, but it sounds like that it would be, the way that they are trying to do this is very beneficial to the company, and potentially very, very significantly serious and effective of your legal entitlements. Again, you would never want to resign from the company. You never should do that. You should require the company that they terminate your employment. If they wish to offer you another job at this new company, again, you'll need to determine, and potentially with the lawyer's assistance, is this actually a comparable job, and do I have potentially a legal obligation to consider this work or not? And the factors that would go into that would be numerous, including potentially what kind of contract do you have with the company that you're currently employed with? Is it a written contract? Is it simply an implied contract or a verbal contract, where you basically are not restricted at all in terms of your legal entitlements on termination, and now the company wants you to go to this other company and sign a much more restrictive employment agreement that really pardon me, limits your entitlements to only the minimums under the ESA, for instance. Just that particular basis in and of itself could be sufficient, to demonstrate that it's not a comparable job, and that the company has terminated your employment, and the current employer must provide you with a severance package. And then, of course, all the other factors, in addition to that, is the work, the same type of work you're doing before? Is your same position? Have they demoted you, promoted you? Is the rate of pay the same? Have they changed your package of compensation? All of these different components, one would look at potentially, where is the new workplace located? Is it located much further from where you previously were employed? Again, there's a myriad of factors here that one would need to look at in terms of determining, is it prudent, or do you have any kind of legal obligation to consider the new employment with this other employer? Typically, the case is that you don't have that legal obligation, that there's something else fundamental here that prevents the employer from doing what they're trying to do here, which is, again, have you resign your employment at this previous employer, and then potentially, who knows what's going to happen with your service there with respect to the new employer. But it sounds like the way they're trying to do this is rather tricky and not really entirely above board. So long and the short of it, Jessica, is wait for the documentation to come out. When you have your documentation in terms of what's actually going on here, reach out to us, at the firm, and we'll have a look over the circumstances here and go much more in depth and thorough than unfortunately we can do over this 15-20 minute Q&A here that's remaining. We can see our link just popped up in the corner there below, but you definitely want to go and get some legal advice here before you take any further steps. Again, it may well be the case that, based on what's going on here, you've been terminated from your employer for all intents and purposes. You're owed a severance package from these folks. And that severance package, again, depending on how long you've been with these folks, may be very, very substantial. So definitely something you want to look at before, again, you make any determination of whether you want to sign a new contract with this other company or not, or whether you even have a legal obligation to do so. So definitely reach out to us. They're happy to assist you, with that in circumstances, because it sounds like, again, that these folks are not entirely operating, above board. Anytime an employer ever asks you to resign, you should definitely, give it a long and hard thought, to be very clear. If not, again, reach out to employment counsel as soon as you possibly can, because an employer obviously to their great benefit, wants you to resign so that they can potentially pay you, nothing in the circumstances, and that's very, very problematic. So definitely reach out to us there, Jessica, about that. Appreciate the question. Looks like some other questions have come in here, which is fantastic. Looks like Stephen from YouTube has asked, if you have a child with a serious illness, can your employer let you go for having to take leave that goes beyond your standard paid time off? So, I mean, if it's no, so if this is an ESA situation. So if you're in Ontario, Stephen, this would probably be, potentially a family medical leave situation, or caring. There's a compassionate care leave as well. Potentially depends on the nature of the illness, but you can the ESA provides for a job protected illness if there's somebody in your family who is suffering a serious illness. I mean, that's just number one in terms of what the ESA provides. Second to that, if you for whatever reason cannot qualify for the minimum requirements that the ESA provides for a job protected leave in these circumstances, then the second thing would be, of course, if the employer is not accommodating you in these circumstances and you've given them, for instance, documentation establishing that your child unfortunately has a serious illness and you require greater time off than whatever your paid time off is provides to you under whatever particular contract you have with these folks. That additional time that you require, again, the employer has an obligation to accommodate you under the Human Rights Code, which is separate from the ESA. Again, assuming that you're here in Ontario, they have a duty to accommodate you in your role. So the employer would need to have a pretty darn good reason in terms of why they couldn't accommodate your additional time off. Provided again you provide that you furnish them with sufficient documentation to establish the legitimacy of this, your concerns here. But they have a pretty darn hard time establishing that that's they don't have that obligation there to accommodate you. And so if they refuse to accommodate you and work with you in that respect, then that could very well be a circumstance where they could be potentially liable for human rights damages if you're terminated, as a result of them not agreeing to accommodate your additional time off. The employer has to work with you. Of course, need to work with the employer as well and be reasonable. But the employer certainly can't just simply, suggest that you okay, well, you're over the paid time off now. You're terminated as a result of that. Again, there's always the underlying obligation to accommodate somebody who has experiencing an issue with. For instance, your child here, who is ill and seriously ill. Again, the employer simply can't just disregard that because you're over whatever your amount of time off is in your employment agreement in the circumstances. So yeah, number one would be to determine do you qualify under the ESA for instance, a compassionate care leave. You may or may not. The definition of that is rather restrictive. Usually you need to have, number one, certificate from a doctor, and number two, potentially the person needs to be extremely seriously ill, potentially very, very serious outcome in that respect. So you may not qualify for that if it's just if it's not, again, like kind of a life or death situation. Otherwise than that, again, the employer still has the obligation of the Human Rights Code to accommodate you in your position and to work with you to accommodate you in that respect. So ask for the additional time off, cooperate with the employer in terms of reasonable medical documentation that they require, be responsive to them. And as long as you do those things, then nobody's going to be able to fault you if the employer acts unreasonably and attempts to terminate your employment because you exceeded the minimum time off that you were afforded. That's certainly not acting reasonably from the employer's part of things. So again, hopefully that doesn't come to that. But if there's an issue in that respect, certainly reach out to us, employmentlawyer.ca. You can get our contact information. We have people standing by all the time to answer calls and to get back to folks who are experiencing, unfortunately, serious and unfortunate circumstances like your own here. So I do appreciate you asking the question and reaching out about that, Stephen. It's a very unfortunate situation, but again, ultimately you are protected here if you're assuming in Ontario, of course, under the Ontario Human Rights Code. If you were in LBC and Alberta, they also have human rights codes as well that would provide for very similar protections. Again, a duty for the employer to accommodate you in the circumstances. So that's certainly something that you should be looking into in that respect. And of course, you can reach out to us as well. So moving right along here in the time that we have remaining, looks like Min from YouTube has asked, what are the legalities of working remotely when overseas? How long can you be in a different country of working remotely in Canada? That's a great question, Min. Not a question that comes up very, very often, but certainly in this day and age when folks are definitely working remotely much more often. I work remotely, for instance, almost always. It's definitely a very, very important question and a great one to ask. So, generally speaking, in terms of working overseas, it's of course possible to work overseas for potentially a brief period of time. The issue becomes if you're planning to kind of permanently move, either to another province, or to another country. If you're going to another country to do work, for vacation for a few weeks, probably not an issue. You let your employer know that you'll be out of the country and things like that. But really beyond about a month, time, the issue potentially becomes, okay, well, whose laws are applying now to your employment and taxation and things like that? Is it, Ontario law or another province's law, or is it the law of another country that's now starting to regulate, your employment and taxation and things of that nature? It's a very, tricky area of law to be, clear about it. Probably your employment agreement, if you have one, stipulates that you must be doing your work from Ontario, on a full-time basis in the circumstances, and that's very, very accurate. Again, except for potentially vacation situations, where again you may take a few weeks off here and there, and the employer knows about it. That's perfectly fine. But again, if it's you're planning to work months and months from another country, that may potentially cause an issue, from the employer's perspective, and again, because of the how our laws operate with respect to taxation and things like that, and how employees are supposed to be taxed. Again, if you're moving out of the country, again, out of the province for a long period of time, again, that may affect what the employer's obligations are, and may cause issues for you, because again, the employer has to deal with the fact that okay, well, what exactly is going on here? And your employment contract probably says something along the lines of, you need to, yes, you can work remotely, but you need to be, in Canada in effect, or at least in the province that you're employed in. Even moving to another province could potentially cause issues. So, long and the short of it is, if you are planning to take anything, of a longer duration than a month or so of working overseas, for instance, definitely you need to have your employer's approval on that, and their consent and cooperation. Certainly wouldn't be a circumstance where you would not want to tell them about it and just do it unilaterally. If they find out about it, of course, then they could potentially have the right to terminate you for cause. So definitely something that you don't want to go into, without having, again, given them prior notice, and of course, obtaining their cooperation and consent, if you're planning again to move out of province for a significant period of time. So hopefully that kind of helps you in that respect. Again, the presumption is for most employers, and for tax purposes, that even if you're employed remotely, that you will be in fact working, from the province of where you are paying your taxes, and certainly the country where you're paying your taxes to, which would be Canada, and presumably also be Ontario. So, again, if it's beyond about a month, definitely get their consent and cooperation if you're wishing to work overseas for an extended time period in the circumstances. So I appreciate that question. And it's a great question. Again, I don't see it too often, but definitely one that's going to come more and more often as we work, as we move towards more remote work, generally speaking. So moving right along here, looks like another question from YouTube. Reggie has asked, pardon me, a little bit under the weather today, as I mentioned earlier. When is an employer allowed to restrict you from getting another job? Like if they only give you enough work for part-time, and they say that you can't get a second job. I have bills. So Reggie, typically the employer can't restrict you in those circumstances from obtaining a second job. If it's a part-time job, I really don't see how the employer could ever, conceivably suggest that you must, work solely and exclusively, only for them. If it's the case that you're working in another, part-time job, as long as that does not conflict with your work for this, current employer, again, I see no legal reason for why you cannot and why the employer would be able to restrict you from working at another part-time job. And again, as long as there's no overlap or a conflict between the positions, I don't see any reason why you wouldn't be able to do that. The only kind of subset or exception potentially to this or asterisk on it would be if the other employer, for instance, if you had signed something about a non-solicitation agreement or something like that, and that for whatever reason, this other job could put you potentially into some kind of conflict of interest with the interests of your current employer, or if for whatever reason, again, this other job could put you in a situation where you would be potentially in a ability to solicit from the current employer, customers or employees or something like that. Beyond that, that very small kind of subset there where there could be an additional restriction. Generally speaking, again, an employer cannot legally restrict you from, again, working two part-time jobs, again, to pay your bills here and make ends meet, as long as, again, your duties and obligations to the current employer are not going to be affected. So you're not going to be arriving to your shift half an hour late. You're not going to be taking time off early because you have another job to get to. Things like that, obviously, you cannot do, and they can restrict you in that respect. But again, there's no overlap here whatsoever. I don't see how the employer can legally rightfully argue that you're in any way restricted from obtaining another part-time job to make ends meet here. It doesn't make sense to me in the circumstances. So that hopefully provides you with some clarity in that respect. Again, long and the short of it is, I don't think they have the ability to restrict you in that regard. You should be able to go get another part-time job. Again, as long as they don't overlap or conflict with each other. So looks like that's almost all of the questions that have come in today, which is great. I'm not seeing too much further here. So perfect. So that looks like it's all the questions for today. So appreciate everybody who's joined us and commented today. If you like what we provide here, then please like and subscribe and join us again. My managing partner, Lior Samfiru, will be doing this tomorrow at 1 p.m., I believe. Yes, 1 p.m. tomorrow, November the 5th. So please join in again for that. And again, everybody, thank you for joining me here this afternoon or this morning if you were joining us from BC or Alberta. Thanks very much, everybody. Take care and have a good rest of your day.